gentlemen at the jail, I'm Wade Mercer. I'm the county judge in Jackson County. On your screen, you will see myself. You're also going to see, hopefully, one of the two attorneys involved in the first appearance process. The assistant public defender, Mr. John McDaniel, is already at the jail. The prosecutor, Ms. Bremer, is in the courtroom. I'm going to ask that she introduce herself.
Kara Bremer on behalf of the state.
Thank you. Can you see and hear both of us at the courthouse, Corporal?
Yes, sir, we can.
Great. Mr. McDaniel, we've got a couple of people that have friends or family in the courtroom. The first is Catrice James. James, good morning. Ms. James, your fiance is here in the courtroom, ma'am, on your behalf. I just want you to know that he's here supporting you. You've been accused of 71 counts of unlawful compensation or reward for official behavior and 1 count of unlawful use of a two-way communication device. This is a warrant that was signed a few weeks ago. So it's been an active warrant now for a couple of weeks. Well, let me look at something here because I want to make sure everything's out of the system now that you're in jail. 23. Mr. McDaniel, there's a information filed, but my question is, was there a warrant also on the same charges? Because if there was, then we've got to make sure both of them are out. Nope. There was just a capias. There was no separate warrant. It was just a capias on the information. So those are the charges you have, ma'am. I've looked at your criminal history, which is pretty good. Actually, it's really good, ma'am, but you've got many serious charges. I feel like I go through this explanation way too often, but the problem I have with the Department of Corrections charges is that one inspector may charge 72 charges at an institution, and an institution across the county may charge 5 for the same behavior. There's no uniformity in how they handle these, and what that does is it creates disparity at first appearances. In other words, I can see this exact same complaint with a different inspector that would charge you with 5 counts or maybe 10 counts, not 71 or 72. So I try to take that into account when I'm setting bond. I'm going to see if the attorneys have any additional information before I address your bond. Mr. McDaniel, anything on behalf of Ms. James?
Your Honor, she works at the Leon County School Board. She's a bus driver. She lives locally, I think, in Leon County. We just, like I say, criminal history, I don't think there's much there. We just ask for some kind of reasonable bond or maybe even a cash bond. I'm not sure if the fiance can pay it or not, but something reasonable.
Thank you. Ms. Bremer?
Your Honor, the state just requests a reasonable bond.
All right. Mr. McDaniel, to try to be consistent with other similar cases, I'm going to set her a $500 bond on each case, cash or surety. At this point, she has 72 counts. That'd be $36,000. I don't necessarily have a problem with a cash bond of the normal 10% that she would give a bondsman. 10% of 36,000. She would normally give a bondsman is $3,600, but she's got so many charges and they're very serious allegations against her. So if she'd prefer a cash bond, I'll certainly consider that and give the state a chance to have input on that. All right, we've got to make a decision. We've got to move along. So I'm going to set you a $36,000 cash.
Yeah, nothing else. 36,000 cash bond. 36,000 surety bond.
Sir, do you have any questions? You can go through a bondsman, and what they charge is negotiable with them. Sometimes they charge 10%. Sometimes they may take 5% down and work with payments. But that's between you and the bondsman. But she's got 71 second-degree felony charges and 1 third-degree felony charge. She's got some very serious charges. Okay. All right. Miss James, do you have any questions, ma'am?
No, sir.
You have a condition, no contact with any Department of Corrections institution while this case is pending as part of your bond, ma'am. You'll get to use the phone shortly if you wish. And as I already told you, your fiance is in the courtroom. He's seen your first appearance. Have a good day, ma'am.
Thank you.
Yes, sir. Yes, she just can't go on property. She can. She just can't go on property. Well, let me be careful answering that question. There's nothing prohibiting her from communicating with you. She just can't go on Department of Corrections property. You may have guidelines in your employment that you need to be concerned about. I have no idea some employers have conditions about associating with individuals with pending charges. So don't get yourself in a bind for your rules. But as far as this, there's no condition of her bond that she not associate with correctional officers. There's just a condition that she not go on Department of Corrections property. Okay. Right. 36,000 cash or surety. Surety is important because that means she doesn't have to come up with all of it. She could go through a bondsman. That's what a surety bond is. Okay. Have a good day, sir. After Ms. James, we have Lucas Williams here. Mr. Williams, Mr. Williams, Mr. Williams, your mother is in the courtroom on your behalf. Mr. Williams, you're here for first appearance, charging one count of trespassing. There is probable cause for the charge, Mr. Williams. I'm going to ask you to listen. I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Williams. At this point in time, he's going to plead of no contest to the charges listed. You understand it? He'll serve 10 days in the county jail. He'll have 2 days jail credit. And he was asking me over and over again, I guess, is that Judge Hatcher there? And just to let him know that the resemblance is very strong, he told me, but they know it's not Judge Hatcher.
Yeah, but
Judge Hatcher's been gone for about 11 years. He's retired and playing golf full time, Mr. Williams. But Mr. Williams, you went to prison several years ago, but your history is not bad at all. I don't think you've been in any trouble since you got out of prison.
no,
That's
sir,
why
I'm going to college.
well, you got an offer of 10 days in jail or probation if you have a place to live. But if you just want to take the 10 days and get over with, that's certainly okay with me. Is that what you want to do?
Yes, sir.
And hang on just a second, ma'am. I think your mother has a question. Ms. Bremer, is that agreeable with the state?
It is, Your Honor.
You have a question, ma'am. Come on up, ma'am, so he can hear you. I want your son to be able to hear what you say. Your mother wants to say something, Mr. Williams.
Yes, sir.
Where's those tissue we had yesterday? We had a box. Did she? Okay. I think we got some in our office. If you need to get some after court today. Yes, ma'am.
That's my son out there on drugs, bad. He's been on the street, been behind the house. They got to eat dog food. My son needs help, and I
Okay.
need help for him to be in rehab.
Okay. When you say your son, I assume you're talking about Lucas, right?
Yeah.
So he's got, and there's a young lady in the courtroom shaking her head too. Your relationship in the courtroom, ma'am? That's
my
your brother? Okay. I wondered if he was homeless because he was allegedly sleeping in a laundry room at an apartment complex.
Don't do drugs. If you're doing it, stop it. Get some help.
He left my house and told me he was grown, even though he got a mental problem. He come back home when he get ready, but he out there sleeping on the street up on the bridge, eating dog food. He needs some help because drugs on just took over his life.
Tell me about the dog food. How do you know about that?
He was on Facebook with some guy, gave him $20 to eat a can of apple dog food.
Really?
That's not right. My son needs.
They videoed it and put it on Facebook? This guy did?
But my son needs some help bad.
Miss Jeffcoat, excuse me, not Miss Jeffcoat. Miss Jeffcoat was yesterday. It's Miss Bremer today. Miss Bremer, does that affect the state's, hearing what his mother has to say, does that affect the state's position on the plea agreement? You want more time to look into it?
Your Honor, I will defer to your judgment on that. I have no objection to this offer. If another offer would be more helpful, we'll just.
Mr. Williams, do you think that inpatient drug treatment would help you, sir?
Yeah. Yeah.
Are you interested in going to a program if we find you one?
Yes, sir. If you get me out of here.
Okay,
I-
today's Friday,
I can pick
Mr.
the
Williams,
10
it's
days.
probably gonna be, it's probably gonna be the first of the week before we can get you in a program. I'm not gonna accept his offer today, Mr. McDaniel, given the input from his mother. I'm gonna ask, Mr. Goodson to look for a program. Mr. Goodson, if you'll ask Chaplain Pippin to maybe, meet with him. And if he's interested in going to a program, I'm fine with getting him on the docket Monday. We normally don't do that on Mondays, but if that's what it takes to get him over there quickly, if he's interested in going, it sounds like he is, I'd like to look into it. So ma'am, before you leave, we'll give you Mr. Goodson's phone number. And what I would suggest is you call him this afternoon and get an update
Okay.
from him. Okay? Thank you for coming.
Mhm.
Okay? I'm going to see you at first appearance Monday and we're going to see where we stand, Mr. Williams. Question, ma'am?
Does he have a bond?
No, that we don't. He can leave. There's no fences in these facilities, but if he leaves, he's violating the court order and he's looking at up to 6 months in
I
jail.
told you.
So the
I told you
incentive for them to
before the-
stay is the pending jail sentence. But most of the programs don't have fences like a prison because they're there to get treatment. So if he leaves, there are consequences. There's several of
So
them we
then-
have to, there's one here in Mariana, the Old Mariana High School is a treatment program, Old Mariana Middle School, excuse me. There's one in Crawfordville called Promised Land. Some are faith-based, some are not. Kind of depends on what he thinks, what he would get the most out of. But he'll have to make that decision and he'll be given some options. And he'll talk to a chaplain who'll make recommendations. And we'll go from there.
All right, all right. Y'all doing
So
too
I'll
much.
see you Monday, Mr. Williams. We'll see where we stand Monday and get an update. Thank y'all for coming. Yes, ma'am. I do have to set my bond though.
So, yeah,
I'm gonna go ahead and set him a bond today of $5,000 cash or surety, so he does have the right to that bond.
Your Honor, is there a condition of no contact with the property?
Yes, no contact with property as a condition of the bond.
I got a bond.
Yeah, Mr. Williams, you have the right to a bond. So I'm gonna go ahead and set you that bond, but if you post it, I can't stop you, but you may want to, if you want help, you may want to stay where you're at until Monday. Back at the top of the list, we have Matthew Jones. Mr. Jones, good morning. Mr. Jones, you're here because you've been accused of violating the terms of your state probation. There's a warrant issued out of circuit court that has no bond on it. Mr. Jones, you're going to be held with no bond until you can get over to circuit court and try to get this allegation resolved. I want to arraign you this morning and get you an attorney appointed to represent you if you want one. I'm aware that you have a private attorney in this case, but that is not on this VOP. The private attorney's filed a motion to early terminate your supervision that was filed before this violation was filed. So I know that Mr. Ramey is representing you and you may choose to hire him on this also. But as of right now, he's not representing you in the violation of probation. He's representing you in that other motion. So I'd like to get you an attorney appointed if that's what you want. Do you want an attorney appointed to represent you in this issue, sir?
Yes, yes, sir.
And you can always hire Mr. Ramey at a later date if you choose to do that or whoever you wish. I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel and we're going to tell you about your court date. One of us will.
Your Honor, we're going to enter a plea of not guilty. I asked to set this on the November 7th court date. Mr. Ramey, I did notice it did get filed after the violations of probation was filed. He had some kind of hearing yesterday with him. But I still, that's no issue with us. So we don't mind. We'll go ahead and do it on November 7th.
Let me check that because I looked this morning and Mr. Ramey, all I saw was Mr. Ramey's signature on a motion. I don't know that Mr. Ramey's filed a notice of appearance in the
I'm
VOP.
just saying that it was after, you were saying it was before the VOP, but it was after the VOP.
Okay.
Yes.
Is that your understanding also, Mr. Fisher? Why would you hire him to early terminate while you had to try to early terminate you while you had a pending VOP?
I didn't have a pending, I didn't have a
Yeah, I
pending
don't think
VOP
that's-
at the time.
I don't think you did either. So
I
we've
didn't.
got well,
Yeah, I think he filed it afterwards, if I recall. But I mean, I'm not saying he talked to him
it's okay.
beforehand.
I don't want to mislead him or leave him confused. So let me look and make sure 21-272 CF is the case number. All right, Mr. Fisher. So what we've got is a motion for early termination of probation that was docketed with the clerk September the 11th. And the affidavit of violation of probation was docketed with the clerk 9 days later, September 20th. And the warrant was 4 days after that. So as far as I can tell, at the time Mr. Ramey filed his motion, the affidavit had not been filed by your probation officer. So I don't think he's representing you in this unless you retain him to do so, which that's up to you. So right now, we're going to appoint the public defender's officer to represent you. You're going to be on that court date. And Mr. Fisher, if you choose to hire him, that's up to you, but I don't at least want to get your case moving. Mr. Fisher, any questions? Did I say Jones?
Jones, yes, sir.
Oh, that's why I couldn't find the case. I was looking the wrong thing up. I apologize.
That's all right.
Mr.
No
Jones,
questions.
any questions?
All right, good luck to you, man.
Have a good day, sir.
Thank you, you too.
Oh, we have two Matthews, Matthew Jones and Matthew Fisher. Okay. Joshua Reagan is next. Mr. Reagan, good morning. Mr. Reagan, you're here for first appearance accused of. I'm a little confused on the charges. Mr. McDaniel, he's clearly accused of one count of petty theft, first degree of between $100 and $750. It looks like the officer accused him of a second count at a different location, but that item was only $8.33. So let me look at the statute the officer cites. I think this is an error, but we'll see. 812.014.
I think he's
1A.
probably had a prior theft charge before anyway, so,
Yeah, he does. He definitely got prior thefts. And it still may be the same degree crime. It just may be the wrong statute.
correct.
812.0141A. That's just a general theft statute. So it appears you've got two first-degree misdemeanors. There are two first-degree misdemeanors for different reasons. I'm appointing the public defender's officer to represent you. Mr. Reagan, this is a bond analysis. Mr. McDaniel?
Yes, Your Honor.
Mr. Reagan, it appears that based upon your history, one or both of these are going to qualify for felony charges. Your history is about as bad as it gets. Looks like you've been to prison 7 times. Is that right, sir? I don't want to assume anything. DOC website shows someone with your same name and date of birth with 7 prison sentences. Is that you?
Let me talk to you about 15 seconds. That is correct, Your Honor.
Okay. So, Ms. Brammer,
Your
It
Honor, I'll
looks like
talk to
it may
Mr.
be.
Reagan. At this point in time, he's going to plead no contest to the 2 charges of petty theft as listed, with the understanding that he'll be sentenced to 9 months in the county jail with public works. He'll have 2 days of jail credit. There'll be a one fine of $370, which we included in that.
so Ms. Brammer, I have no problem with that agreement as long as the state's okay with it. He may qualify for a felony. The officer charged him with 2 misdemeanors for whatever reason, The state want to go ahead and resolve it today if Mr. Reagan wants to.
In the interest of judicial economy, yes, Your Honor. And I wasn't clear, did Mr. McDaniel say that restitution was reserved?
I don't know if he said that, but I'm sure he meant that. Mr. McDaniel?
Oh, yeah, we reserve it, or you can just tell us, I mean, it's in the complaint what the numbers are. There'll be a civil judgment against it.
I think, I don't know if the battery is resellable or not.
I'm not sure. either.
I think that's probably the hesitation. So reserve restitution up to the amount in the complaint that will be the maximum amount. And it obviously will be a civil judgment if it's ordered at that amount in the complaint. Ms. Brimmer, for the restitution, the cap on it would be how much, ma'am? Be the battery plus the $8 and some change.
Correct, 136 for the battery and then the 833.
So the restitution will not exceed $150. Mr. Reagan, is that the plea you want to enter to resolve these cases, sir?
Yes, sir.
You accept your plea of no contest to 2 counts of first-degree petty theft, 2 counts of first-degree retail theft is what it actually is. Adjudicate you guilty, sentence you to 9 months in jail, give you credit for 2 days you've served, $370 court costs and fines, reserve jurisdiction up to the amount of $150. And I recommend you for the Public Works Trustee Program, Mr. Reagan. That will hopefully allow you to get you some gain time and get out a little earlier. Mr. Reagan, there's no probation in this case, and it's being handled as a misdemeanor at the agreement of everyone this morning, and I do wish you the best, sir.
Thank you, sir.
Yes, sir. Keandre Riley is next. Mr. Riley, good morning. Mr. Riley, you're here for first appearance accused of 1 count of burglary of an unoccupied dwelling, 1 count of criminal mischief, and 1 count of possession of paraphernalia. I read the complaint this morning. There is probable cause for those charges. Mr. Riley, I'm going to appoint the public defender's office to represent you for first appearance purposes. I also looked at your criminal history, and Corporal, you may or may not have this, but it looks like Mr. Riley has a very recent jail sentence, so he must have just gotten out of jail within the last few weeks. Corporal,
Yes,
or
sir.
sergeant, whoever else is in the-
Last few
Say again,
days.
please.
Yes, sir. Thursday he was released and I transported him to Liberty County on a hold that they had, and he went there Friday for first appearance.
As in last week? Last
Yes,
Thursday
sir.
and Friday?
Yes,
All
sir.
right, so Mr. Riley, let me see if Mr. McDaniel or Ms. Brimmer have any additional information before I address your bond. Mr. McDaniel,
I don't have anything, Your Honor.
Ms. Brimmer?
Did the state request a reasonable bond and no contact with that property?
Thank you. Mr. Riley, your second degree felony, which is a mid-level felony, is very serious charge. That's the burglary. The bond will be $50,000. The other two will be $5,000 each. Your total bond is $60,000. You've got a condition, no contact with that property, which is changed names. It's Cabana Garden Apartments, formerly now known as Three Rivers Apartment Complex, I think. You can't go back on that complex at all, Mr. Riley, while this case is pending. But you do get to use the phone, sir, in a few minutes and try to post the bond. It's cash or surety. Mr. Riley, do you have any questions, sir?
No, sir.
All right, have a
When
good
I
day,
come
sir.
back to court.
Okay, that's a question. We'll try to answer it. What happens is the state attorney's office has 40 days to charge you from the date of your arrest. If they don't charge you within 40 days, you're entitled to be released. But if they charge you, Mr. Riley, that will then put you on the next arraignment docket. So you're probably going to be, he's not gonna make November. He might make December. What's the December arraignment date on Judge Garcia's calendar? Most likely going to be on the December arraignment date, which will put you on December the 5th, most likely. And that's my best guess. Okay.
Yes, sir.
Have a good day, sir. Rebecca Young. Ms. Young, good morning. You're here for first appearance. You're accused of 4 charges. You're accused of 2 counts of battery, 2 counts of regular battery, misdemeanor battery. Those are both domestic violence cases. 1 count of battery on a law enforcement officer, that's a felony charge, and 1 count of resisting an officer with violence, that's a felony charge. Ms. Young, I'm going to appoint the public defender's officer to represent you this morning and ask that you listen to Mr. McDaniel, your attorney. We'll see if he has any additional information before I address your bond. Mr. McDaniel.
Your Honor, Miss Young works at Taco Bell at the TA here in town. She lives in town, lifelong resident of Mariana. I don't think she has any criminal history. We'd ask the court to consider a conditional release on.
Yeah, I'm not going to give her a conditional release with battery on the Leo charges, and she does have some criminal history, I believe, as a juvenile. I saw something in there. Let me refresh my memory.
I'm trying to, make the battery sound better than what it is, but I think it was a spitting incident. The battery is not, based on her.
Thank you, Mr. Young. Mr. McDaniel, I did note that she's accused of spitting on an officer, which is probably less damaging and more insulting. But her behavior in the back of that patrol car, as it's alleged by the officer, is horrendous. Allegedly repeatedly trying to kick out the windows of the patrol car. So she's not going to get a conditional release from me, and I'm probably going to set her the normal bond, but I want to see if she has juvenile history or not. She does have juvenile history here in Jackson County, 2019-51 CJ sexting. Juvenile sexting, I guess, is the charge back then. So that's not something that's going to affect you today. That's a non-factor because it's a juvenile case and because I think that was just a citation offense. It's really not something that's going to affect your bond. You're going to get the standard bond, Ms. Young. Your bond's going to be $5,000 on your 2 felony charges, ma'am. $2,500 on your 2 battery cases. Your total bond is $15,000. Ms. Young, it's cash or surety that can go through a bondsman, but the issue is right now you've got a condition, no contact with either alleged victim. I believe one of the alleged victims is your mother, and one of the alleged victims is your fiance or boyfriend, whatever the relationship is. So you can't go back to the home they're living in. That's your biggest issue right now, Ms. Young. Mr. McDaniel, if she finds somewhere else to go, I probably wouldn't consider a conditional release because of her charges, even if she has somewhere else to go. But I might consider a cash bond or something like that if she has somewhere else to go. But the complaint is maybe the worst. That's not the worst one I've got today, but it's not good at all. So, Ms. Young, you've got the right to post bond, ma'am. You'll use the phone in a few minutes. You cannot call either of the alleged victims, though, for purposes of posting bond. You can call anyone else you wish. Ms. Young, do you have any questions?
My mom said she
can't-
was dropping charges.
Okay, there's some people in the courtroom who weren't here when we started court earlier, I don't think. So they just got here. So I didn't tell you they were here because I didn't know. So your relationship?
Is my mom?
Okay. Whether you press charges or not, first of all, it's not your decision. I just want to explain how it works. You can make a request to drop charges if you wish, and the state attorney's office will decide that. Secondly, the case involving the law enforcement officer, you're not the victim on. So even if you ask to drop your case, that has nothing to do with the state's going forward in that case. That's helpful that you're here and I appreciate you being here. So the question I have for you is this, there's obviously some issues. This is not normal behavior when someone consumes alcohol. They don't act in the way that she allegedly acted. So it makes me wonder, does she drink? Does she always behave this way when she drinks? Was there something besides, let me finish my question, ma'am. Was there something besides alcohol that she consumed?
I don't know, I wasn't there.
Well, you obviously were there if you're the victim.
I came in after.
Okay. There's a truancy case I saw this morning, a prior truancy case. So it appears there's been behavioral issues in the past. So is there a history of alcohol abuse even at her young age? Not that you know of. What about other drugs? Okay. If she were to get out of jail, do you want to have contact with her? Okay, you're not afraid of her? Are you? The first time this happened, I understand that, but there's some issues there in the past. Okay, what about this? I'm not going to give her a conditional release. It's just not going to happen with allegedly spitting on an officer and trying to kick out the windows 5 or 6 or 7 times of a patrol car. It's just not going to happen. But if she does get out of jail, you have no problem with her coming home. Is that right?
Well, we got a place for her to go if she does get out.
Where would that be?
Daryl's mom.
Probably my mom's house.
And that would be Daryl's relationship to,
Fiance.
okay,
Yeah, that's fiance.
okay, and it's Daryl's mother's house she can go to. Okay. So does the boyfriend that's the other alleged victim, does he live with you?
No, he lives on the property that we're renting from his back. So,
The complaint alleges that you live together as a family unit, the two of you and the two of them. Is that not accurate?
it's the same address, but we live in a separate house. They do.
Miss Young and the
Yeah.
boyfriend lived in one.
With the fiance's dad, they were in that house. We're renting the other one and staying.
And the place where she could go is on a different property totally. It's not even the same area. Okay. All right. So Ms. Bremer, given that, I'm probably going to set a lower bond in anticipation that battery charge may be dismissed. And I'm also encouraged to know that she has a place to go. I'm still not going to give her a conditional release with what she's accused of. Did I get to the point of setting the bond? I'd set 5-5 and 25-25. I'm going to cut them in half then. So the bond's going to be $2,500 each on the 2 felonies, $1,250 each on the 2 misdemeanors. That makes a total bond of, help me out here, $7,500 cash or surety. If you go through a bondsman, that means $750. Ms. Young, your bond has a condition of absolutely no contact with either no contact with your boyfriend. I'm not going to put a condition, no contact with your mother, because she's here and wanting contact. You have a condition that you not possess or consume any alcohol, and also no other kind of medication or anything that you don't have a prescription for. So you could be drug tested, because the behavior, frankly, is, I don't see a lot of people doing what you're accused of doing who just have alcohol in their system. It makes me wonder if there's something else in your system. So no alcohol, no drugs without a prescription, no contact with a boyfriend at this point, and your bond is $7,500 cash or surety. And Ms. Young, do you have any, Mr. McDaniel, go ahead. Were you saying something, Mr. McDaniel?
No,
Okay.
no, I didn't.
Ms. Young, do you have any questions?
Can she come get me?
So in the courtroom, do you have any questions? So, yeah. And what you may want to do is you may want to talk to Ms. Bremer here with the state attorney's office if you hang around, if she has time. Do you have time to talk to her?
Yes,
Ms.
sir.
Bremer's the prosecutor. So given her lack of any adult history, the state may, my concern is, does she need inpatient alcohol counseling? Is there something else besides alcohol in her system? Those are the questions I have. But you may want to hang around and talk to the prosecutor, because I may be seeing her next week. The state and defense may have reached out some other kind of arrangement to get her out of jail with some kind of counseling, something in effect to make sure this doesn't happen again. I'd rather get her attention now than have her continue down this path. It looks like she's headed down. All right. So your mother's going to talk to the prosecutor today, Ms. Young, and Hope you have a good day, ma'am. Thank y'all for coming. Crystal Allen is next. Miss Allen, good morning. Miss Allen, you're here for first appearance. This time you're accused of 5 counts of forgery, 5 counts of uttering a forced instrument, and theft of a person 65 years of age or older. Corporal, the jail sheet doesn't say anything about other charges, but the complaint makes it sound like she's already in jail because she was interviewed at the jail. So what else does she already have? And what, does she already have bonds on other cases, Corporal?
She's got a
If they'll put
violation of
that on
state
the-
probation. She's
Oh,
got a
okay,
violation of
well,
state probation and a couple other cases also that John Young's representing her on, so she's not going nowhere.
She's got a total
Does
of
the VOP have-
$39,000 bond set already.
Does the VOP have no bond on it, Mr. McDaniel?
Correct.
All right, so I'm going to set you the bond today, $5,000 on each of these charges. There are 11 of them. Your bond for today, Miss Allen's $55,000, cash or surety, no contact with the alleged victim. Miss Allen, keep in mind what Mr. McDaniel just said. There's no point in posting this bond if you got a violation of probation because you wouldn't get out anyway. Miss Allen, but that's your bond today. Any questions, ma'am?
No.
Have a good day. After Miss Allen, we have, is it Natarisha?
That's
right. Natarisha. Miss Natarisha Smith is here for the charge of violation of county probation. Miss Smith, you're accused of violating in terms of your probation by not reporting several months. And then there's some financial issues. Ms. Smith, I'm appointing the public defense officer to represent you. I'm going to ask that you listen to Mr. McDaniel, ma'am, and we'll see where we go. Mr. McDaniel.
Your Honor, I think she's gonna end up pleading, but she's gonna ask the court for a witness.
I was wondering if I could have at least a day or two. I was in the process of moving out of house, and I work at the Florida State Hospital too. I want to try to get my stuff out the house so I won't lose everything. And I want to try to, what I want to do, I want to leave my job. My mind is so boggled right now.
I know you said you wanna go talk to your employer.
Yeah, I'm gonna try to talk to my employer, at least put a written note in so I can resign immediately or something, so I maybe be able to get my job back when I do get
All
out.
right, you're not getting out of jail. You're on probation. You're accused of violating your probation in substantial ways. I don't do that. And I'm surprised that you work at Florida State Hospital with this history. You work as a state employee or you work for one of the private?
No, I don't have it. I've never been in trouble before, as far as coming to jail.
You don't have a possession of drug without a prescription charge in Bay County? Is
No,
that not
sir,
you?
that's not me. That's not me. I'm sorry. I just got out. No, sir, that's not me.
Okay. Let me look at, while I'm pulling this up,
Sir?
yeah, I think it may be a different date of birth. I may have the wrong, the criminal history that's not yours. Ms. Smith, let me ask you this, while I'm pulling up what we do have in my system instead of the jail system, have you ever been charged with a crime anywhere?
No, sir.
You've never been charged with any crime anywhere?
I was charged with a crime. I've never been convicted of anything.
Okay, I asked you the same question twice, and you gave me 2 different answers. I'm gonna ask you a
I
third
couldn't hear-
time, and I need
I couldn't hear you,
listen,
sir.
listen to the question. Stop talking, listen to the question. If you don't understand the question, let me know that, but don't lie to
Okay.
me. Just tell me the truth. The question
Okay.
is, have you ever been convicted of a crime? Actually, the first question was, have you ever been charged with a crime anywhere?
Yes, in Louisiana,
Okay,
about 20,
how long ago
25
was
years.
that?
About
How
20
long
years
ago?
ago. 20
All
years
right.
ago.
And nothing since then?
No, sir.
Okay, are you a state employee or are you an OPS
Yes.
employee?
No, sir. I'm a state employee.
And how long have you been a state employee?
I worked OPS for 2 years, but then I just started, for this year right here, I just started in a main position. I just started my permanent position.
Mr. McDaniel, she's accused of not reporting for multiple months. She's accused of not reporting for June, August, and September, and then there's some financial issues. As you know, the financial issues don't concern me as much as the non-reporting. The not reporting is a serious allegation for 3 months. I don't see many state employees that are accused of not reporting on probation. Normally, a state employee is more responsible than that. So I'm not going to ask her at this point why she may not have reported, or if she disagrees with that. But Mr. McDaniels, anything you want to tell me? I'd like to try to save her job if we can, but if she didn't report, unless there's a really, really good reason, I got to do something to her.
I don't know if it's a really good reason. I think she said that she had some medical issues and she
I
was
was in the hospital
hospitalized. It couldn't be for every month though, I don't think, but.
In June, I was in the hospital for over a month. I came home with a PICC line in my arm, which left me not being able to go anywhere or do anything without being able to go anything. So that's why I didn't report in June, but I did go in July. However, in August, when they got ready to get the PICC line out, it was infected, so I went into the hospital again, but I called them and I told them. And then September. Sir?
You were in the hospital over a month in June?
No. I was in there for over half of a month, but the other half, I was, I came home
I
with a
think you
PICC
just
line
said
in
you
my
were in the
arm.
hospital over a month. Didn't she say that?
I said over.
You just said you were in the hospital a month in June, over a month, I think is what you said.
No, I know, sir. I said a half of month. And I said over half a month in
Okay,
June.
let's do this. I'm gonna hold you with no bond. I'm gonna see you again Monday. I'm gonna watch the video from this morning and see if you've told me contradictory statements. I believe you have. But if I can help you on Monday, I will. If I feel like you're misleading me, then the offer's already
I'm
been
not
made.
misleading you, sir. Can I
I'll
just-
see you
maybe
Monday.
I'm
You have no
over-talking because
bond.
I'm
You got to
nervous.
quit talking while I'm talking. You have no
Yes,
bond
sir.
at this time. And the other thing I'm gonna do, Mr. McDaniel, if you can please contact her employer, because if she still has a job, I'd like to know that. If she still has a job and we can save it, that would be something I would like to know. If they're going to terminate her for all this being in the hospital for over a month or half a month or whichever it is, plus getting arrested this time, then that job is no longer a factor if they've already terminated her. So
Yeah,
Mr. McDaniel, you may be able to help her in that regard. I'm going to see you on Monday. Do you have any questions, ma'am?
No, sir.
All right, see you then.
No, okay, no, I'm gonna.
So it's no bond for the time being. Now Matthew Fisher. Mr. Fisher, good morning. Mr. Fisher, Mr. McDaniels added you on the docket today to try to see if we can possibly get your case resolved. I'm going to ask that you listen to your attorney, sir.
Your Honor, I spoke to Mr. Fisher in case number 23648 MM. At this point in time, he's going to go against my advice and enter a plea of no contest to the charge of simple battery, amended to simple battery. The understanding, he'll be placed on probation for 11 months, 29 days, pay a $722 fine. He'll take a domestic violence class while he's on probation, get signed up with that within 60 days. The reserve on restitution and no contact. Amber Munn has 20 days jail credit as of today.
Ms. Brimmer, is that agreeable with the state?
It is, Your Honor.
Mr. Fisher, did you hear that agreement?
Yes, sir, Your Honor.
Mr. Fisher, do you have any questions about that agreement?
No, sir, Your Honor.
And Mr. McDaniel said this was against his advice, which typically means he wants to do some more work on the case. He feels like you may have some valid defenses, but ultimately it's your decision as to whether you want to do this or not. Do you still want to do this, even though Mr. McDaniel is saying he'd like to work on your case a little longer?
Yes, sir, Your Honor.
All right, Mr. Fisher, the question I have for you is where will you be living? Because my memory is you were living with the alleged victim's family when this happened. Are you going back to Alabama or are you going to stay here or what?
Yes, sir, Your Honor. Alabama.
Okay. And this is what you want to do, correct?
Yes, sir, Your Honor.
Mr. Fisher, I'm going to accept your plea. Ms. Brimmer, I'm sure that I don't want to assume this, but I know that in the battery case, the state attempts to notify the victim. I'm assuming since it's been added to the docket, the victim's okay with this, or alleged victim?
Yes, Your Honor.
Mr. Fisher, I'm going to accept your plea of no contest in case 23-648 MM. The charge is simple battery. I'm going to withhold adjudication of guilt. Sentence you to 11 months and 29 days probation. Mr. Fisher, you'll have the standard conditions of probation, plus you'll pay court costs and fines of $722. The counseling box does not check. What type of counseling is it? Mr. McDaniel, what type of counseling is it? Anger management, domestic related? It'd be anger management, wouldn't it?
Anger management's fine. It said domestic violence classes on my offer, but anger management, I think is probably the same thing.
And normally, if they're going to stay together, you'd want to do some kind of domestic classes. If they're not, it'd probably be an anger management class. But either one is fine with us. If she ends up wanting to reunite, which I don't think that's the case at this point. No contact with the alleged victim at all at this point, and reserve jurisdiction on restitution. There may be restitution in this case.
Let me, I had it pulled up. I'm sorry, Your
No,
Honor.
it's no problem.
It's no
No
longer there.
problem. It's just I try not to reserve it if we know. And since this was 20-something day old case, you may or may
Right.
not have heard back from her yet.
We
Mr.
have,
Fisher, give us just a second. Ms. Brimmer's looking to see if they have a victim impact statement to see if there's any restitution alleged. I don't remember a hospital visit or anything in this case, so there may not be any, but we'll look and see.
I didn't recall seeing any kind of restitution in the complaint or.
Yeah, I heard from my grandmother that she didn't want anything done as far as like restitution.
I don't see any request for restitution, Your Honor.
Okay, so there's not gonna be any restitution, so we'll drop that. And Mr. Fisher, could you hear the explanation I gave to the last young lady about using the phone, getting dressed, setting up transportation, and then being brought to the courthouse? Could you hear all that?
Yes, sir. Can you please explain it again? I want to make sure.
Sure. I
that-
just want you to know what's coming. So you're going to get to use the phone in a few minutes. Call friends or family for transportation if you wish. I know that your dad has expressed interest in this case. He's called on your behalf. He's called my judicial assistant. So he called wanting to, basically he called the note in the file. Now, I've not spoken to him, but there's a note in the system that says he called saying that the bail jumping charge was in 2021. In reality, your criminal history shows 2 bail jumping charges, one in 2021, but an earlier one earlier this year. So that was explained to him. But the point I'm making is that he's called on your behalf. He's trying to help you. So you call whoever you want, call your dad, call whoever you want, and you can tell them that you can be picked up in about a half hour at the Jackson County Courthouse. It may take him longer to get here. That's fine, but you'll be ready to leave in about a half hour because they're going to let you get dressed. They're going to let you use the phone. Then they're going to bring you to the courthouse where you can meet with one of the probation officers, either Mr. Goodson or Mr. Ham. Once you meet with them, you're going to be free to go in roughly a half hour from now. So that's what's going to happen next. Mr. Fisher, do you have any questions?
No, sir, Your Honor. Thank you so much.
Have a good day, sir.
You too.
Kiana Williams. Ms. Williams, good morning. Ms. Williams, you're here on a petty theft charge, ma'am. I think Mr. McDaniel's added you on the docket to try to see if we can get this case resolved. So listen to your attorney, Mr. McDaniel.
Your Honor, I spoke with Ms. Williams in case number 23656MM. She's on her plea of no contest. The understanding should be sentenced to 30 days in the county jail, $370 fine, 18 days jail credit, and that will take care of this case. She has signed her plea waiver form, waiving the right to jury trial. and all cases.
Thank you, Mr. McDaniel. Mr. Brimmer, is that agreeable with the state?
It is, Your Honor.
Ms. Williams, did you hear that agreement?
Yes, sir.
Ms. Williams, is that the plea you would like to enter to resolve this case, ma'am?
Yes, sir.
All right, Ms. Williams, I'm going to accept your plea of no contest to the charge of retail theft. The judge you guilty sentenced you to 30 days in jail. You've got credit for 18 days you've already served, Ms. Williams. I'm going to order court costs and fines of $370. That'll be reduced to a civil judgment because you're not going to have any probation. Ms. Williams, you finish this 30 days, you will be released without any probation. You have 12 days left at most. The reason I say at most, Ms. Williams, is you may get a day or two gain time for good behavior. That's between you and the jail and Florida law. Ms. Williams, do you have any questions?
No, sir.
All right, Ms. Williams, wish you the best, ma'am. I think we have Michael Brady. Mr. Brady, good morning. Mr. Brady, I've got a letter in my hand from Chief of Police, Marion Police Department Chief Baggett. Mr. Brady, if we get a letter from a written request for early release from the person, the person over the agency that's doing your trustee status, and then not commonly, it doesn't really happen that often. It's the first time it's happened this year. I'll consider releasing the person usually 7 to 10 days early for just doing an above average, well above average job as a trustee. This letter from Chief Baggett says that you have been an excellent trustee. You've been with them several months and that you've done everything that's been asked of you and more. And based upon that, he's asking that some consideration be given to you. He's requesting approximately 10-day early release. Corporal, where do we stand on Mr. Brady's normal release date?
His scheduled release date is 10/17, so it's roughly about 8 days early.
Well, 10/17. 10/17 would be 11 days.
I'm sorry, it is.
1 day doesn't make a difference to me, but I just want to make sure we're right.
Yes, sir. It is 10/17 is the scheduled release date.
10/17, so that would be the end of next week or Actually, it'd be the 10/17 would be the Tuesday after next. So based upon Chief Baggett's letter, that's why you're being brought up today. So I want to listen, see if Mr. McDaniel has additional information, maybe Corporal Jones might in this case, and Ms. Bremer obviously may have some input. Corporal, anything from the jail on Mr. Brady or the chief's suggestion?
No issues. Mr. Brady's always done excellent work as a trustee every time he's been here, and we've never had any disciplinary issues with him at any time, so.
The other thing the chief's letter points out is he's incarcerated not for crime of violence, but for driving offense. Is that right, Mr. Brady?
Yes, sir.
And the chief says that's kind of a circular thing for you that's kind of got you started in trouble. You actually went to prison one time for driving offense. Is that accurate?
Yes, sir.
Okay. And that's good. It's good that that's the charge. If there's a crime of violence or a battery, we have to give the alleged victim an opportunity to have input, and sometimes they'll feel strongly against this kind of early release. Mr. McDaniel, anything on behalf of Mr. Brady?
No, Your Honor.
Ms. Bremer?
Your Honor, the state has no objection.
Mr. Brady, I'm going to grant you the early release requested by Chief Baggett based on your performance as a trustee at the Marion Police Department. Sir, you're going to be released from jail today. Mr. Brady, stay out of trouble. Wish you the best. Any questions, sir?
No, sir. Thank you.
Wish you the best, sir. You're welcome.
Thank you.
Do y'all have this in your file? If it's not, we need to make it part of the file, please. All right, so Mr. McDaniel, I think that takes care of the in custody cases. I know that we have Mr. Brown in the courtroom, but anything else at the jail before we call Mr. Brown?
No, Your Honor.
Corporal, anything else from the jail this morning, sir?
No, sir, that's everything.
Thank you, Corporal. We will see you Monday. In the courtroom, we have State versus Evan Brown, 23-496 CT. Mr. Brown, come on up. CT 496. Mr. Brown, give me just a second to get that case pulled up. It looks like, how old are you, Mr. Brown?
Just turned 19.
Okay, you look young. You look about the same age, actually. Mr. Brown, let me see what we got here. I remember looking at your history earlier, and you had no history at all if my memory's right. Mr. Brown's 23-496 CT. Mr. McDaniel, charged with driving while license suspended or revoked. He had a court date for, well, July 31st. He missed the court date, and then someone called on his behalf saying that there had been some confusion. Mr. Brown came from, where did you come from today, Mr. Brown? Dothan?
Yes, sir.
Mr. Brown came from Dothan and tried to get this matter resolved. We put him on the first appearance list, and the reason I did that is because the state's offer, had he shown up at arraignment, was simply a fine. Based upon his history, the state wasn't asking for any kind of probation or incarceration or anything. So, Mr. Brown, I'm appointing the public defender's officer to represent you. Listen to Mr. McDaniel, your attorney, by video there, and we're going to see where we stand. Mr. McDaniel.
Thank you, Your Honor. I spoke to Mr. Brown at this point in time. He's going to plead no contest to the charges listed. The understanding that he's going to pay a $400 fine within 60 days, or he'll serve 10 days in the county jail.
Mr. Brown, any question? Excuse me. Let me ask you this question first. Any chance you've gotten your license issue resolved?
So, I mean, this is the last thing I have to get resolved.
This is the only thing that's keeping you from getting a license, but you can't do it because of this active warrant.
Yes, sir.
Is that right? All right. Yes, ma'am. There's another.
Speeding ticket.
There's a civil infraction. Okay, so we'll deal with the speeding ticket in just a second. Ms. Bremer, is that resolution agreeable with the state?
It is, Your
And
Honor.
what about the standard language decrease in the fine if he does get his license?
No objection, Your Honor.
Mr. Jones, I'm going to accept your, Mr. Brown, I'm going to accept your plea of no contest. I need you to sign this waiver of rights form. This form right here waives your right to a trial and your right to call and cross-examine witnesses, and it enters your plea that we just put on the record. I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly. I'm going to withhold adjudication of guilt. That's important because that means you don't have a conviction on your record, okay, based upon your age and your lack of any history. I'm going to sentence you to 10 days in jail, but you will never serve that 10 days. as long as you pay the court costs and fines. Now, the amount of the court costs and fines depends upon whether or not you're able to get your license. The amount of court costs and fines are $400. That's set by state and county law. But if you get your license within 60 days, I'm going to lower it by $100. I'd rather you take that $100 and spend it to get your license than I would you to pay it towards a fine. So it's either 400 if you don't have a license, it's 300 if you do have a license. It's 60 days to do it either way. You have until December 6th. Now, Mr. Brown, this court disposition you're about to get has a court date on it of December 7th. So it's due by the 6th. If you get it paid by the 6th, you don't come back to court. Sir, if he gets it paid by the 6th, it's over. The reason there's a court date on here is sometimes people can't get it done. Something will happen. They'll have a job, a car accident, a job issue, and they can't get it paid. If you can't get it paid by the 6th, you come in on the 7th here at 8:30 and say, Judge, I've got half of it paid. Can I get another week, 2 weeks, whatever? I'll listen to you and I'll make a decision. But if you get it paid by the 6th, you do not come to court on the 7th. That's only if you need it. Okay? Any questions on that charge?
No, sir.
Okay, so let's talk about the speeding ticket. You got a speeding ticket the same day and same time, right?
Yes, sir.
All right, let's look and see the speed on that speeding ticket. Are you a student? Are you employed or
So I'm
both?
both. Kind
It's not neither, hopefully.
I'm employed and a student at Wallace.
Okay. 67 and the 45 is the speed. What are you studying at Wallace?
Trade program,
What trade?
mechanics,
What kind of diesel or gas?
just basic mechanics.
Basic mechanics?
Yes, sir.
All right. Let me ask you a question about my son's truck wasn't cranked this morning. I'm just joking. So with your being a student and with your history being so good, if you want to plead no contest to the speeding ticket, I'm going to waive the points and waive the fine on it. And the reason is you've already got the fine in the other case. I don't see a point in really another fine of $278. So if you want to plead no contest to the speeding ticket, I'm going to waive that points and waive those fine. All you'll have is that one case to deal with. Is that what you want to do?
Yes, sir.
So I plead no contest, Madam Clerk, to the speeding citation, waive the points, waive the fine. We need to actually do it less than 10. The reason we need to do it less than 10 is because you have a license in the state of Alabama. And I'm afraid that if we show a plea of no contest to the actual speed, even if I waive the points and fines, it could cause you some license issues. Hearing Officer Larimore is actually in the courtroom. I know North Carolina's like that. If you plead over 15 miles per hour over the speed limit, they'll suspend your license, period. Is Alabama like that too?
No, I don't think Alabama, North Carolina, but I just had one.
So we're going to show a plea of no contest. I'm sorry, what'd you say, Don? Georgia's the other one. I'm going to show a plea of no contest to less than 10 miles per hour over, waive the points, waive the fine. So that one's over with. You've got that case left. Does he need to go downstairs to get the clearance paperwork? Or what? Yes, obviously, we're going to, thank you, Mr. Goodson. Okay. So we're going to set aside any warrant because of you allegedly missed, because you missed the court date. And Miss Williams here, you need to go downstairs on the east side of the courthouse, and because you may need some paperwork to take back to your driver's license office in Alabama.
Yeah, one of these right here. Clearance letter. All right.
And I'll figure out the battery issue on my own, okay? Any questions?
Yes, sir.
To his dad in the courtroom, any questions, sir?
No, Your Honor, I am a mechanic, so I can tell.
Well, I opened my son's hood when it wasn't cranked this morning. I saw the battery cable. I think I know the issue. I think it's a maintenance issue, but I wish you the best.
Thank you.
Thank y'all for coming. Thank you for getting that resolved. Yes, sir. Y'all take care. Mr. Goodson?
Can I ask Mr. McDaniel something?
Sure.
Mr. McDaniel, you know if the chaplain's working today?
I have not seen him, but I can find out real quick, maybe.
That's all right. I'll call out there. Okay, it's fine.
Yeah, I didn't see him this morning when I come in, though. Yeah, I didn't see his
Mr.
truck.
McDaniel, thank you. Mr. McDaniel, that's everything I had on my list this morning. Anything else from the Public Defender's Office?
No, Your Honor.
Ms. Brimmer from the state?
No, Your Honor.
And Ms. Williams, the clerk's office, anything else? All right, so ladies and gentlemen, if you're watching by YouTube, hang on, don't disconnect yet. If you're watching by YouTube, that concludes first